Little Russia.
Yes.
Russia.
PP is not there.
Kindly see the base
PP
70
is there.
FI.
Yes. Why it is listed? Earlier it was rejected by this court.
My lord?
Whether earlier it was rejected,
No, my lord.
This is
It
the-
was withdrawn.
it was withdrawn.
Withdrawn.
Okay. Yes. Make your submission.
My lord, one Sudipta Goswami lost the affair that his father led Dr. Ramananda Goswami purchased a plot of land measuring 1 katha 10 lasa covered by dag number 100 KP Patra number 250 at village Betkusi under Moja Beltola from one Mistress Lily Begum. Then the state land was grabbed by some miscreants, and the informant lost Azahar after 6 months. And kindly see the affair was 70.
Who are you?
My name is
Your name
mentioned in the affair, but
Your-
I am not involved in this.
your name. You are named accused.
Name is Kingsman.
What is your name?
Simon.
What is your name?
Simon Baru. Illiterate person, my lord. I am illiterate person. And
What is the allegation against you?
allegation against you in the affair, the informant stated that some person along with me by making fake documents occupied the informant's land. This is the allegation.
What is your case?
My lord, I am not involved in this case. In this case, one advocate also involved. One Mintu Kumar
No,
Raha.
FIR was lodged in the month of December 2023.
After
Now it is May, 5 months. Now why are you apprehending arrest now?
my lord,
Till now you are not arrested.
no, my lord.
Now why are you apprehending that?
My lord, I am apprehending that my elder brother was taken to the police station and asked about myself.
We will peruse the case there. Case there is there.
Case is not, it is come from the motion stage.
Let us call for the case.
Case that may be possible.
Mr. What is your name?
P.A. Ahmed.
P.A. Ahmed, learned counsel for the petitioner. Also heard Mr. R.J. Borua, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973, has been filed by the petitioner, Shri Simon Boro, who is apprehending his arrest in connection with Gorsuk PS case number 325/2023 under section 120B/467/468/447 of the Indian Penal Code. Perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary.
Hello.
When
10th of June, Lord, sir.
fixing 10th of June for case diary. Now call item number bail hearing. Item 2 we will take after some time, after bail hearing. Third item we will take.
May please, your lordship. The 438 application, my lord. Your lordship have protected me by the order dated 13/5/24, my lord. Accordingly, I have appeared before the IO and I recorded my statement. my lord.
My lord, in this case, lordship, we have only received the part of the case diary before lordship. Because in the, my lord, forwarding report, my lord, I has mentioned that, my lord, the Nagaon PS case number, my lord, case diary of the Nagaon PS case number 231 has already been sent to, my lord, of the learned trial court, my lord. Learned-
For charge sheet has been laid.
No, my lord, for, my lord, maybe some other bail application is
My
pending.
lord, one of the accused has been, my lord, released on bail.
Remaining part of the, my lord, case diary has been forwarded to us, my lord. And wherein, my lord, is accused person, my lord. his
What was
statement
the
has been
allegation?
Recorded, my lord.
Allegation, my lord, allegation is that, my lord, the prime accused has collected some
Now,
documents.
Mr. Borwa, what is the submission? He has appeared.
He has
Whether-
a statement recorded, but my lord, the entire, what is the allegation against him, lordship?
You
that I
want
don't go
the
through.
case diary to be perused.
Yes, my entire case diary to be produced. my lord.
Okay. Heard Mr. T. K. Bhuya, learned counsel for the petitioner. Also heard Mr. R. J. Borwa, learned additional public prosecutor, who submits that the case diary of Nagaon PS case number 231/2024, which is available before the court, is a part case diary. And he submits that for consideration of the instant bail application, perusal of the complete case diary would be necessary, and prays for some more time for producing the entire case diary. The prayer is allowed. Let this matter be listed when,
Since he is on interim, lordship, we'll fix it on, my lord, 14th of June, my lord.
let this matter be listed again on 14th of June. The interim order granted to the interim bail granted to the petitioner shall continue till next day.
Obliged, my lord. But, my lord, I am not the FNM accused, my lord.
Okay. No, you are on
Interim.
under protection.
Deeply obliged, my lord.
After some time. 3 months. This is not 3 months. 2.
I can do it. I can do it.
Yes.
The Lordship, on 6/1/23, we tried to contact the petitioner for payment of 20,000, but however, we have not established any contact till date. So Lordship, we kindly pass any other as
Then we are dismissing.
Yeah, yes, ma'am.
As per last order, Lordship has decided to, because they have not appeared on last 2 occasions. And thereafter, Lordship, this order has been passed to deposit of 20,000 at the time of admission. And that order has been vacated by your Lordship on 29/8/2023. Lordship,
Now, whether it has to be decided on merit
Lordship,
or merit, if I have to decide it on merit, then you have to argue.
Lordship, I'll argue. I'll argue the case.
But without admitting it, how we can decide it on merit?
Admission, earlier admission was made subject to deposit of rupees 20,000. That was not deposited, so admission goes. So Lordship may dismiss this petition for
Heard Mr. S. K. Goswami, learned counsel for the petition. No, what is your name?
S. Sharma.
Heard Miss S. Sharma, learned counsel
Lordship,
for
S. Sharma appearing on behalf of Mr. D. Chaudhary.
S. Sharma, appearing on behalf of Mr. D. Chaudhary, learned counsel for the petitioner. Also heard Mr. S. K. Goswami, learned counsel for the respondent number 1, as well as Mr. R. J. Borwa, learned additional public prosecutor, appearing for the state respondent. Learned counsel for the petitioner has submitted that though by order dated 7/2/2018, the petitioner was directed to deposit an amount of rupees 20,000 before the trial court as a condition precedent for admitting this revision petition, and the counsel for the petitioner had tried his best to contact the petitioner. However,
He also issued a notice also that has been marked as Exhibit X.
However, the petitioner has not come forward to deposit the said amount. It also appears from
Document X.
record that the learned counsel for the petition, who had sent this notice? Learned counsel for the petitioner, who had sent this notice? Petition,
Mr. N. Ray.
learned counsel for the petitioner had also sent a notice to the petitioner informing him about the fact of informing him about the order of this court regarding requirement to deposit the amount of rupees 20,000 before the trial court as a condition for admission of this instant criminal revision petition. Stop. It also appears that as the petitioner had failed to deposit the amount before the trial court as directed by this court by an order passed on 28/8/2023, this court had vacated the stay order granted by this court on the execution of the impugned order, making it clear that the trial court would be free to proceed with the execution of the order under challenge in the present criminal petition. Stop. As the petitioner has failed to has failed to comply with the condition precedent for admission of this criminal petition, even after lapse of more than 6
5
years, 5 years, 5 years,
More than 5 years.
more than 5 years, this court has no other option but to dismiss this instant criminal revision petition, which it accordingly does. This criminal revision petition is accordingly dismissed with above
Obliged.
observation. No, okay. Nothing was called for from the trial court.
Lordship, LCR should be returned.
LCR was, let the case record of the trial court be returned back to the trial court along with a copy of this order.
Lordship may directly register immediately to send the record. So otherwise,
Registry to send the record to the trial court immediately.
obliged.
May I please, your lordship, my lord? Last time I argued, my lord, my argument has been, my lord, concluded, my lord. And I, for your lordships, my lord,
Concluded, then why it was kept part heard?
my argument was concluded. My point is that, my lord, basically my point is that
No, why it was kept part heard then?
only public prosecutor
Okay, public prosecutor has to reply.
has to submit.
What was your submission?
My
In
sub-
brief, you
In
can,
brief, my lord, I am submitting, my lord. My submission is that, my lord, that NDPS, my lord, 13 bottle of cough syrup has been recovered, only 13 bottle, my lord. And petitioner was behind the bar for 2 years, 8 months, 29 days, my lord. As on today, my lord. Right? 2 years, 8 months, 29 days, my lord. And my lord, what happened, my lord? If your lordship go to the evidence of PW1, my lord, it was recovered from the veranda. And they, in their evidence also stated there's some other person inside the house, my lord. That is, and PW2 has said same thing, what PW1 has said. But PW1 is that there are no other persons, whereas PW2 said that PW1 is presence, my lord. And another thing is that, my lord, in respect of my main point, my lord, 52A, my lord, was not complied of, my lord. 52A, my lord, there are 3 certificate is required, my lord. One in respect of inventory. That certificate is also, my lord, defective, but that certificate was given. Secondly, my lord, in respect of photograph of the, my lord, contraband substance, my lord. That photograph also, my lord, certified, but list of sample, my lord.
No. How 52A was violated? Firstly,
Yes, my lord, I'm coming, my lord. There are 3 certificates required, my lord.
under 52A.
52A, my lord. I am coming, my lord. No, 52A today.
Yes.
52, my lord, your lordship kindly come to 2A. Have your lordship got it?
52.
2A.
Yes.
Yes, my lord. Certifying the correctness of the inventory so prepared,
No. That's
taking in
52.
presence of such magistrate photograph of such drug substance, certifying such photograph as true, that too certificate is available. In respect of inventory, I will argue later on, my lord. Allowing to draw representative sample of such drugs or substance in presence of magistrate, and there is a conjunctive word and, my lord. Certifying the correctness of a list of samples so done. That was not given, my lord. That certificate was not given.
So allowing the
Yes, my lord.
draw of representative samples
Yes, my lord.
of drugs
Yes, my lord.
or substance in
Yes.
presence of magistrate,
Yes,
that
my
is
lord.
one aspect.
Yes, my lord.
And thereafter
Yes,
certifying
and
this,
certifying the correctness of any list of samples so done.
so
That was.
correctness of any list of samples
Yes,
drawn.
my lord. And they admitted in their objection also. They have issued 2 certificates, my lord. That third certificate is not available, my lord.
No, what was the first certificate?
First certificate in respect of inventory, my lord.
Inventory.
Yes, my lord. Inventory that is defective, my lord. I saw one thing, my lord. That is why third certificate is mandatory.
Second is photograph.
Yes, my lord.
Third is list of samples, according to you.
Yes, my lord.
And in this case, list of samples was not
Yes, sir.
certified.
And what happened, my lord? In this case, my lord, only one bottle sent to the FSL, my lord. If my inventory why defective, if they mention the batch number of the bottle, my lord, then that is different aspect of the material. They have admitted that out of, my lord, 13 bottle, one bottle sent to the FSL, my lord. The other bottle may not be, my lord, NDPS substance, my lord. That is also defective. I am not on that. I am third. That is why, my lord, third certificate is necessary, my lord.
No, but can I look into it at the stage of 389 application? This is an application under
Yes, my lord.
389.
Your lordship.
Prima facie,
Yes, my lord.
I have to
And there is a many judgment, my lord, where
That-
bail has been granted.
52A.
Last time I showed all the judgment, my lord. If your lordship want to show, my lord, I can show all the judgment where bail has been granted, my lord. Only thing last time your lordship.
Mr. Borua, you are ready. Their submission is 52A is violated, which is mandatory. And any violation of 52A would entitle them to get bail, even after conviction. So
why harm
their submission is list
will-
of samples was not certified as
Yes.
per 52A to C.
The question is that, my lord, whether at this stage, lordship, this is a, my lord, application under section 318 and CRPC, lordship. Whether at this stage, lordship will, my lord, reappreciate the evidence, entire evidence, lordship.
No, if apparently, that is my question to both
My
of
lord.
you. At this stage, if something is apparent, if ultimately, if they get benefit of, because deciding this question may decide your appeal also. If I hold that 52A is not violated, is violated,
Yes. One
Ye-
thing is that, my lord, there is a order also, my lord, there is judgment, my lord. A prima facie, my lord, from the objection. It is apparent. It is not that so big
okay,
things.
okay, Mr. Borua, you answered this query.
Yes,
My
my lord.
lord,
whether 50, this list of samples
my lord,
as pointed out by Mr. Chaudhary,
so my lord,
whether it was certified or not in
My
this
lord.
case. From record, you can verify.
my lord,
Only that thing.
If it is not certified as required under the provisions,
my lord,
they
53,
may get benefit.
my lord.
For that reason, this was fixed, my lord.
No, that it comes some other day also. I'll
No,
go
no,
to
no.
that.
We are not postponing it. We are deciding it. I will, you,
My lord, I have to go through, my lord.
You go through. I'll fix it for orders, delivery of orders.
Yes, my lord.
You just point out
My lord.
whether list of samples is verified.
Yes, yes, my lord.
It can be verified even now.
Yeah, I'll go through, my lord. I'll go
If
through
it is not there, you inform me. If it
My
is
lord.
there, you inform Mr. Chaudhary also
My lord, my lord.
that it is there, what he has to say. Is it okay?
My lord.
Your submission is that there is no list of samples.
There is list of sample was not certified. List is also not available. List of sample is not also available. There.
So what was certified? Only
Only my lord,
photographs
photograph
and
inventory.
inventories.
These two, sir. They have stated in their objection also. They have written objection. This only, my lord. And my lord, what substance has been recovered from the, my lord, veranda of the petitioner, my lord? 13 bottle of cough syrup, my lord.
Normally, there is a certification
Yes,
when the sample is drawn.
My lord.
That certificate may be present.
That I'll go through the record, my lord.
Let him go through
Yes.
yes, ma'am.
and we'll take it up again
Yes, ma'am.
in the second half.
Yes, ma'am.
During lunch hour, you go through.
My lord.
In the second half, we'll take it up again. If he finds out, we'll dispose it off because it is coming on many occasions. Okay. You go through.
My lord. Oh, lordship may fix it on next Tuesday, my lord. That it will be, my lord, because I have to go through the, my lord, law point also, my lord. Whether he's entitled.
Last several time they have taken.
No, my lord, I did not appear, my lord, last occasion, lordship.
One
Subject to, my
after
lord,
another,
provision.
last 4 5 days. And my lord, what is the goods recover, my lord? 13 bottle
So
of
13 bottle is a commercial quantity.
my
lord.
humble submission.
10 bottles becomes commercial
My-
quantity
my humble-
and 13
No,
bottle
my
is
lord.
absolutely
My
commercial
humble
quantity.
submission before your lordship is that, my lord. There are other point also, my lord, in respect of bail also I can argue. Only on this point, they let them satisfy.
Then lordship may had the entire appeal, lordship.
No, no.
We prepared the
only-
entire
only-
appeal. Why,
only
why,
this
why
point.
the 318 application, lordship? Because egos of 37 will be there, my lord.
The
No, my lord.
impugn.
That has been done. No? There's a
Hmm.
decision. Recently, I got a decision, my lord, of the appeals court. In 389, bail can be granted. Your lordship kindly go to the, I have marked the paragraph number, my lord.
Dadu.
Dadu. Dadu, my.
No, when the impugn order was passed, impugn judgment was passed
Judgment.
in this case,
In this case, judgment was first 27/7/2023.
23.
Yes, my.
So
We
this,
immediately filed the appeal, my lord.
okay, let him go through.
Yes, my.
We are fixing it on Tuesday.
Tuesday, my lord, yes.
Tuesday,
Only thing, if you also honorable division bench seat, my lord.
no, I'm giving a fixed date,
Yes, my lord.
keeping it part. Earlier, no fixed date was given. Heard.
Then, my lord, your lordship can fix it, my lord. Not Tuesday, my lord. Election result will come, my lord.
Okay.
Then, my lord, it just fix on my lord. 6, my lord.
6, my lord.
7. 7 number 1.
Heard,
7,
Mr.
my lord.
Okay.
10, my lord. You will not be able to. 10, my lord.
Heard, Mr. N.N.B. Chaudhary,
10
learned
June, my lord.
learned counsel for the petitioner. Also heard Mr. R.J. Burwa, learned additional public prosecutor. Though Mr. N.N.B. Chaudhary had concluded his submissions, learned additional public prosecutor, Mr. Burwa, sought some time to go through the records and make his submissions. the prayer is allowed. Let this matter be listed again on 10th,
10, my lord.
10th
June, my
of June.
10th of June, my lord.
And my lord, in
Hello.
Dadu's case also, my lord, 37 will have to be taken into consideration.
On 10th.
37 applicable,
Yes.
389, they said, my lord. there is a
10
clause
June.
that- Last time.
He-
Other
and I said
petition-
that is what, my lord, it was Maktul Singh, it was
They are
Wait,
elect-
no.
Maktul to
Chandra.
Maktul
Yes,
Singh
my
case
lord.
was
He
unconstitutional.
is
That was-
on
Maktul
Stephen
Singh was
Kuri.
declared
But lord,
unconstitutional.
37 will, then
No,
also
no, I am
37
not
will.
37. Last time other PPI said, my lord,
No,
389.
if both of you are very eager, we can take it now also. We can refix it today.
I am
But
ready,
not
my lord.
10 laws, because I have to go
I
through
am
a record
ready
and
to
some
do
law point also, but I'll go
Okay,
through. my lord.
then let
Okay,
it,
by law.
then reserve
So-
your submission
Yes,
for
madam.
10.
Only last chance may be given, my lord. Otherwise, another PP will come, said, my lord.
That is the difficulty, also, actually, we are also facing.
Say that he has
Because, my
admitted,
lord,
my
yes, this is the true, my lord, because
No, but
today I am in this.
That is why last chance your lordship kindly I done, my lord. Otherwise, my lord, it matter.
no, I have named him. Mr.
It will-
Arjibur.
Yes, my lord, my name may be
His
mentioned.
name is reflected
Yes.
in the order.
Yes, yes.
Gentleman, number because-
And there is my, we are facing in all the court losses because somebody else appeared, today I am appearing, my lord.
Okay, let it be on 10.
Yes, sir. You can write again.
In my name.
That's okay.
Please, your lordship. Lordship, AB, my lord, this AB was filed in September, my lord, last year. Lordship was pleased to grant us interim protection while order dated, my lord, 25/9/2023, my lord. Subsequently, we appeared and we gave our statement. Thereafter, my lord, the informant came and filed an IA for vacation of the interim order, my lord.
Okay.
And since then, the case has been coming up for orders, my lord.
This I is for the,
They have filed the IA. Now they have also stopped appearing for the last 4 or 5 days, my lord. They filed saying that after being granted interim bail, we threatened them, my lord. My lord will kindly see their statement also, my lord. In the IA page 3, my lord. Para 3, page 3, para 3.
yes.
The stereotypical allegation, my lord, that after getting the interim bail, we went and we threatened them to withdraw the FIR, my lord. That is the allegation, my lord. My lord, we have already been granted interim protection, my lord. This should make
FIR is under
306, my lord. My lord, what has happened in this case, my lord, the victim Mariam was married to one Mojibur who already had
yes,
another wife.
Mr. Borua.
No, there's one more issue, my lord, I will point out, my lord. On the last date, my lord, it was pointed out that charge sheet had been filed in the case. And it was pointed out that charge sheet was filed in November itself. However, my lord, the case diary was available till February in this honorable court. And last one in February, it was sent back for FSL report. Now, as per the report, my lord, it shows that charge sheet was filed.
Without case diary, how charge sheet?
My lord, that is something
My lord,
was confusion, my lord.
PSK number.
Julia PSK is 22420. We have verified, my lord, charge sheet has been filed. Now, what
Okay.
they have said is that they have filed a charge sheet in November itself. Whereas till February,
Now,
February it was sent back.
the-
An order also, my lord.
you have appeared before the
No, my
trial.
lord, we have not yet appeared.
You have received
We have, only-
summons.
we have received summons, my lord. This case is fixed in June. So we'll appear, my lord.
Let him appear then, lordship, my lord.
However, my lord, the only case is a case under 306, my lord. We'll appear before a magistrate court, my lord.
No, the question is whether to decide this interlocutory application for cancellation of bail
My lord.
where the petitioner is not present. What is
I
to
would
be
have
done?
ये लोग ना है, बहुत दिनों से appear नहीं। Last 4 or 5 occasions, my lord, they have not appeared. With otherwise,
No, but the order sheet
because
reflects.
my lord, the matters did not reach
Okay.
on, but then they were also not present, my lord, even on the last date, my lord.
Then we are not dismissing it today. We are fixing it on Monday. Monday or Tuesday. Instead of deciding it,
As my lord thinks.
the applicant, none appears for applicant on call. Mr. S. Nawaz appears for the respondents. Learned additional public prosecutor is also, Mr. R.J. Borua is also present. This application has been filed for cancellation of interim That interim bail has not yet been made absolute.
No, my lord, that is still pending.
Okay,
They came in while during the pendency of the AB, my lord. So this AB has been pending for the last, since September, my lord. And since the date is fixed for our appearance, my lord, that is the problem, my lord.
okay. This interim bail has, this interlocutory application has been filed for cancellation of
More complex.
interim bail granted to the petitioner by order dated 25/9/2023. Passed in AB case number 3282/2023. As the applicant is not found on call, let this matter be listed again on when to fix it.
My lord, any convenient date next week, my lord. Fixed, my lord.
Tuesday,
Tuesday, my lord. My lord.
Tuesday is,
Fourth, my lord. Fifth, my lord, is possible.
okay, on 5th of June 2024. In interlocutory application. Heard Mr. S. Nawaz, learned counsel in main AB case number 3282. Heard Mr. S. Nawaz, learned counsel for the petitioner. Case diary is not there.
Case diary not received, my lord.
Charge sheet has been laid on now.
Started has been, my lord, that as informed by my granted friend.
Okay. Learned additional public prosecutor submits that case diary has not been received. Stop. Learned counsel for the petitioner has informed this court that in the meanwhile, charge sheet has been submitted. Learned counsel for learned additional public prosecutor is requested to verify and let this court know on the next date as to whether case diary has been laid in this case or not.
Charge sheet.
Charge sheet has been laid in this case or not.
Yes.
And whether
24.
the petitioner has cooperated in the investigation or not. You take telephonic interview. Let this case be listed again on 5th of June 2024.
Interim to continue.
The interim order shall continue till next day.
I'm deeply obliged.
I'm sorry, Lordship, I've overheard the
Rules.
Yes, Mr. Mundi.
Lordship, ganja Lordship of 20.400 gram Lordship, 20 kg, 400 gram Lordship. That was recovered from the position of the petitioner Lordship. And charge sheet was filed on, he was arrested on Lordship 11/1/2023. Eleven 2023 Lordship. And charge sheet was submitted on 28.
This can be a substitute.
Scan copy is there. Now, this is a commercial quantity.
Lordship.
What is your ground?
Ground Lordship, that Lordship will kindly see, he was arrested on Lordship 1/1/2023 Lordship, that 506 days as on date Lordship. Charge sheet was submitted on Lordship 28/2/2023. Immediately within 2 months Lordship, the charges has been filed. And thereafter Lordship, it took almost 5 months for charge framing. Charge was framed on 7/7/2023 Lordship. It took 5 months Lordship to frame the charge Lordship. And thereafter, the first witnesses has been examined on Lordship 21/5/2024 Lordship. This month.
How many?
Out of 8 witnesses, one has been examined on 21/5/2024. It's the delay Lordship, that within 2 months, the FIR charges has been filed, 5 months it took to Lordship charge frame and.
You were arrested on 11/1/23.
Lordship.
Now, how many days you are behind it?
506 Lordship.
It comes to 1 year.
1 year around 4 months, Lordship.
4 months.
And Lordship,
It will be,
Lordship,
my lord,
see
more
the
than,
delay,
more
Lordship.
than 550 days, Lordship. Then, my lord, 1 year, 6 months will come, my lord.
So the only thing is that Lordship, within 2 months, the charge sheet has been filed. That is my contention, Lordship, of the delay. And it took around, Lordship, 5 months for charge frame.
No, but you will not get benefit unless you can show.
This is the Lordship on record, it shows, Lordship. It took 5 months for charge frame, Lordship, within.
We'll direct to complete the the,
Lordship, only 400 grams more, Lordship, than intermediate quantity. Lordship.
but it is more.
To 20.4, 400 gram, Lordship. It is ganja, Lordship. Only 400 gram more than intermediate quantity. It's not heroin, it's
When,
ganja.
what was the last date of,
This is the
Yeah.
21/5/2024 is the last date where PW1 has been examined. This is a,
which is the next date fixed?
next date is fixed on 14/6 for evidence. This is
We'll-
a, sir, Lordship,
We'll fix this case after 14/6.
Lordship,
We'll see how we.
Lordship. It's better than the got rejected.
Heard Mr. S. Muni, learned counsel for the petitioner. Also heard Mr. R.J. Burwal, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 506 days in connection with Special NDPS case number 62/2023, which is pending before the Court of Learned. Which court it is pending?
This is,
Which court it is pending?
This
Learned
is just
Special Judge NDPS Kamrup
Kamrup Metro, my lord.
Metro. Learned counsel for the petitioner has also submitted that only 400 grams more than the commercial quantity of the ganja has been alleged to be recovered from the possession of the present petitioner. And in spite of having been detained for last 506 days behind the bars, only 1 out of 8 listed witnesses have been examined. Learned counsel for the petitioner has also submitted that the next date of the NDPS case number 62/2023 is fixed before the trial court on 14/6/2024 for examination of prosecution witnesses. Considering the submissions made by learned counsel for the petitioner, let a report be called for from the trial court as to number of witnesses examined after 14/6/2024. The trial court is also directed to expedite the recording of witnesses in view of the long incarceration of the present petitioner. Let this matter be listed again on when to fix. Last part of June,
28, my lord.
28 June,
this is the last day, Lordship. Can it be
Okay, okay.
26 or 27? Like
27 June. Registry to call for the status report of the status report as regards the number of witnesses examined by the trial court after 14/6/2024 to be placed before this court before the next date fix. list accordingly.
Lordship, sorry, Lordship, that regarding 27, can it be on 24? Because again, the another date will come nearer.
Okay,
Because it
24.
is on 16, 10 days, again, 4-5 days will come, Lordship, again it will come to near. So,
But then you will not be completing 1 year, 6 months. And unless you bring some authority, you may not get benefit of 1 year,
And it took-
27.
Lord. Much obliged, much obliged.
Yeah, madam, I adjourned for the day, madam. I guess council MH is not available.
What is your name?
A Ahmed,
J.
A Ahmed,
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R.J. Burwal, learned additional public prosecutor. Learned counsel for the petitioner has prayed for an adjournment on the ground that the engaged counsel for the petitioner, Mr. M. A. Chaudhary, has some personal difficulties today. Considering the submissions made by learned counsel, the prayer is allowed. When should we fix?
sir, 1 week, madam.
Let this matter be listed after 1 year.
Okay. Please, madam.
In this matter, I filed an additional affidavit to bring on record certain certified copies of
You
ROC
have filed,
documents.
already
I've
filed.
already filed. I've also served it upon my learned senior colleague. I believe it is not on record. He just
Then
and praying
how
for.
will we proceed? It has to be brought on record.
If it may
Now,
be
what is your
requisition, it may be requisition, my lord, post lunch.
that may be done. Then we'll take it after lunch.
Please.
Sandan, additional affidavit. Okay, we'll take it up after lunch in the second half.
All right.
Russ, look. 1 minute. Next item, Matthew.
May I please, my lord? My lord, this matter may not be taken today, my lord, because, my lord, the son of this appellant, he is also an advocate. He has engaged me in this case, but suddenly he has to went to Gulaghar. So some part of the record is done with him, my lord. So this, on any day on the next week, my lord.
Okay, what is your name? What is your name?
My lord,
What is your name?
M. Agarwal. I'm sorry.
Heard Mr. M. Agarwal, learned counsel for the appellant who prays for an adjournment on the ground of some personal difficulties. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks. Item 9, none appears for the petitioner on call. Let this matter be listed after 2 weeks.
It is valid crossing petitions. The crossing petition is page. Pending before the court of the land at Maidstone Division of Society matter. Your lordship can just see the complaint petitions. And may read out. That is very simple, my lord. Actually, what happened, the complainant took a loan of ₹4 lakhs from petition number 2, my lord. And in return, he has executed power of attorney in the name of the petition number 1, who is the son of the petition number 2, to purchase, sale a plot of land measuring Mijai, one kotha Devendra Shah, situated Vishana Sahibu.
No,
But-
what we will do, Mr. We will take it in the second half. Now,
After lunch.
after lunch, we'll take it up.
Let's.
Probably Lordship has already heard my first part. Lordship remembers
How
Or
much
I
time
think-
will you take for reply?
I'll endeavor to conclude by 30 minutes.
Then why I'm putting these queries? We have a matter of Kohima bench. We will defer that Kohima bench matter today. Will Mr. Miss Sokri,
Yes, Lordship.
Mr. Chaudhary is waiting, my lord. Probably that matter.
uh, you have already concluded.
Yes, I have concluded, Lordship.
You have concluded.
No,
Yes,
reply. Yes, sir.
How much time you will require? Then we may not take up your matter today.
Your lordship, can it be next Thursday at 4 PM? That will be better actually. Then there no clash out, otherwise everything it will push back. 4 PM is the right time for me. Next Thursday.
Okay, we are deferring Kohima bench matter to Thursday.
3:30, if I start at 3:30 then. Okay.
Kohima bench matter Thursday, fixed on 6th of June at 3:30.
Lordship, much better.
Yes, we'll take up your matter. Yes, you have to refresh the memory.
Yes, my lord, just I'll refresh the memory, my lord. This is basically, Lordship will remember, this is a dispute between the complainant and her sister-in-law regarding the illegal transfer of the shares, my lord. There's a company called, my lord, Hotel Dynasty, my lord.
under the Rahman Properties Limited, my lord. So, my lord, there are 3 directors at the time. Adilur Rahman, then the complainant, and one Mr. Sajat Haq Maulam. They are the 3 directors of the company, my lord. Then, my lord, the Adilur Rahman, he unfortunately expired on 13/11/2012, my lord. And as per the complaint petition, my lord, admitted fact that he used to run the business of the day-to-day business of the company. Now, after his death, my lord,
Adilur.
Adilur Rahman and her sister, Dr. Nilufar Rahman, they happens to be the director, apart from one Sajid Haq Maulam. So, my lord, the
When it was last heard
last heard, my lord,
on 1903,
April, my lord.
when you made your submissions? 1903.
Maybe 1903.
Just a minute, let me see.
Nineteen three, my lord.
Yes.
Probably your lordship has noted down
Yes,
the,
yes, I got my notes.
yes,
Adilur died on 13/11.
13/11/2012, my lord. Now, admittedly, my lord, the paragraph 4 of the complaint petition, it says, my lord, the Abdulur, he used to run the day-to-day business of the company.
Yes.
Then, my lord, there's an allegation subsequent to his death by the complainant and the sister of the Adilur that the share she used to hold, my lord, that has been illegally transferred to the accused person, that is her sister-in-law and the daughter of the Adilur, my lord, accused number 2. To them, the illegal transfer of share. That is the basic case, my lord. That without her consent, without her signature, the share has been transferred illegally to us, my lord, to the accused. Now, our contention is that, my lord, in this case, my lord, admittedly, my lord, share has been transferred. There is no dispute on that fact, my lord. Share has been transferred. There is no dispute.
But it
Now,
was
when-
prior to death of the Adilur.
But yes, my lord, that has been transferred prior to the death of the Adilur Rahman. My lord, as per their own document, my lord, there are 2 transfer form, my lord, which has been relied by the complainant itself as part of their document, my lord, that lordship will find in our petition. There are 2 transfer, lordship will find page 17 and page 21. First, the share been transferred to Afroza Rahman, that is the sister-in-law of the complainant. Now, lordship will find that that is the figure 218100, that is the figure in the column, first column, that is the figure, and this tallies with the number 2,18,100. Then the consideration amount, and lordship will find in the top of that page 17, my lord, there is a stamp of the authority concerned, my lord. It was presented on 18/1/2012, my lord.
Yes.
And this document was prepared, Lordship will find, on 5/1/2012. Approval date, the last part in the
Yes.
bottom, my lord, that
Yes.
is the approval date. So on that particular document was prepared and subsequently on 18/1/2012, this document was presented before the authority for the transfer of the share. That is the page 17. And the next lordship will find page 21. Similar document, my lord. This is the transfer to the Ajana Rahman.
Yes.
That is the daughter of the accused number 1. 8,400 shares, my lord, in figure. Similarly, on this document also, date, it is the 5th day of January 12. This was prepared and again, it was presented again the same date on 18/1/2012 before the authority.
Yes.
So admittedly, these documents are relied by the complainant himself, my lord, in the complaint petition. It is their document. So admittedly, this share has been prepared, the transfer certificates been prepared and presented before the authority prior to the date of the Adilur Rahman. And at that time, we are not in the business of that particular company. At that time, the complainant and one Mr. Maulong and Adilur, they happens to be the directors of the company. We are not directors at that particular point of time, my lord. Admitted. So subsequently, it has been prepared and presented before my date. Now, their contention is that in the paragraph 9 of the complaint petition, they have intentionally, what they did, my lord, to make out a case against me, they wanted to show that, lordship will find that is in page 141, it starts the complaint petition. Paragraph 9, 143, para 9.
Yes.
Now, in the paragraph 9, what is their contention is that the share which has been transferred to Adil's daughter, that is the accused number 2, it was transferred on 17/12/2012. There's a chart they have prepared, and there's a date is put in the second column. Lordship will find that column.
712.
That is in 7/12/2002 to 2012. So they want to show that because the Adilur expired on 13/11/2012. So they want to show that this transfer has been made subsequent to the date of the Adilur Rahman, but which is contrary to their own document itself, which they are relied on. Actually, what has happened, my lord, it was presented actually, but because the Ajana Rahman, at that time she was in outside, residing outside the country, so share could not be transferred. Subsequently, the formalities has been done. So lordship can define also in the page 21, on behalf of the Ajana Rahman, somebody else has signed it.
For Ajana.
For Ajana, as she was not there.
Okay.
And they have also admitted in their petition that we have also replied, they have made some few letters were written to us, and they are also admitted that part that as Ajana was not there. We have also
But
replied.
this share transfer form was filled up on 5th of January.
Yes, yes.
And it was presented on
On
18th of January.
But in the complaint petition, they meet paragraph 9, they want to make it to make out a case that this transfer been made subsequent to the date, so that they can implicate us for illegal transfer of the shares after the death. But it is contrary to the fact that their own document itself.
Okay.
And in paragraph 10, they have made this allegation that the last 3 lines of the paragraph 10, besides 8,400 numbers of shares were admittedly transferred after the death of Adilur Rahman. So for the said transfer, accused person have show space
No,
for their explanation, no space for their explanation. So that is their contention, but which is contrary to their own document. Now, there are several,
no, on what basis they have mentioned these dates, 7/12/2012?
that's they only knows, my lord, because
They have not
they have
given
not,
any support.
yes, to that effect, there's no document, only that is the allegation. But
Okay.
they're not saying anything about that, how they came to know that has been shared, has been transferred,
Okay.
not supported by any of the document, madam. With the complaint petition and the annexures. Now, Lordship also can see the admittedly in the complaint petition, they have said there are several letters been exchanged. And admittedly, the complainant also said she has written several letters. The second letter that is very important, that is page 133. So this is the letter written by the complainant to accused number 1. The point D, my shares, Rahman Properties have been transferred illegally by falsifying my signature. You have mentioned in your letter to me that the shares were transferred during my late brother Adilur Rahman, tenure MS MD of the company. It may be so. It may be so. Lordship kindly mark it. It may be so, but that still does not make the share transfer illegal. I have not signed the share transfer form during his tenure either. So, admittedly, they say that it may have happened, but the share transfer was illegal. We are not on that, my lord. And they have also filed, my lord, in the enter this particular letter, that is, my lord, Annexer 11, page 133, that is the second letter issued to me. There was no allegation that we have transferred the shares, my lord. Or in the complaint petition, my lord, there's no allegation to that effect that we, in connivance of the Adilur Rahman, has transferred the share in our name during his lifetime.
No, no, no. In para 10, they have stated that after the death of Adilur, you have
Yes.
transferred. So there in para 10,
Yeah,
they have
that's
made-
right. The para 10, that's what I'm saying, that the para 10 and 9, if we read together, 9 and 10, these are the allegations, my lord. But it does not support,
no supporting document is
Yes.
there.
rather
But they-
their own document says it was transferred prior to death of the
Yes.
Adilur.
But the allegation
Allegation is that
after,
it was after the death.
after the death.
But my contention is even assuming there's no allegation to that effect, it is not their case that they, during the lifetime of the Adilur, in connivance with us, Adilur has transferred the share during the lifetime with our connivance.
That allegation.
That
is not-
allegation is not there.
Okay. And documents shows that it was transferred
Yes,
much before the death of the
yes,
Adilur.
yes. That is our basic case, man. So that the complaint petition and the letters issued to us, it appears that rather it was an afterthought. Because all the communication made, the admitted communication, the letter, there's no allegation. They have filed one title sheet also, that the title sheet will lordship will find, that is in page number 102. For the same transfer of the share, in title sheet also, there is no allegation to that effect that we have transferred the share illegally, my lord. Neither in the letters, neither in the title should. So in the complaint petition in paragraph 9 and 10, for the first time, they have come up with this allegation, my lord, which is not supported
Title suit was filed prior to the
Yes.
complaint.
prior to complaint. So in that, and the letters was also prior to the complaint. Nothing, no allegation to that effect. Now,
Yes.
now most important part is the initial deposition, my lord. Here, the initial deposition also been recorded of the complainant and the mother. Complainant's own mother has been recorded, my lord.
Where she has said that
Yes, my
it
lord.
was transferred prior to
Yes,
the death of
yes,
Adilu.
yes. Both, my lord, the
And Ramina Rahman, CW2 says that it was Adilur who transferred the
yes,
share.
yes. That is
So allegation was against against
Adilur.
Adilur, not
yes,
against you.
not against us.
Okay.
So that sealed the whole case, my lord. Because their own witnesses testified before the court under section 200 and 202 of CRPC that it was the Adilur who has transferred the share in the name of the accused, and the complainant also, rather, though she has in the paragraph 9 and 10, she said the transfer was subsequent to the date, whereas her own statement says no, transfer was done prior to the date of the complainant, of the Adilur. Her own statement, ma'am. So that is our case, my lord. So from that, my lord, and apart from that, my lord, one more. So this is our basic case, my lord. Then, my lord, the cognizance was taken by the trial court under 468, 420, and the 471. So regarding the 420, as lordship knows, there has to be some deception on our part for transferring the share. But to that effect, there is no avertment in the complaint, neither in the initial deposition, that we have deceived the complainant to transfer the share.
Okay.
So 420 does not come anyway, because as lordship knows, for the 415, there has to be initial deception by the accused. And that deception has to be fraudulent. So to that effect, my lord, there is absolutely no allegation, so there is no question of 420. Now the only 468. Now the 468, it was the Adilur who has transferred the share, and there is no allegation that we are, and there is no allegation, the 471, there is no allegation in the complaint petition or in the that we are aware of the fact that this is a forged document. To make us liable under 471, my lord, as lordship knows, we must have the knowledge that it is a forged document and we are using it. But here, the using of document does not come because that was placed by the Adilur itself. We have not used also.
Now, what is the status of shares? Whether these are
That
already
remains,
transferred?
because it's no. Shares is which is transferred. But there is civil suit is the
Shares are with you now.
yes, yes. The civil suit is going on to that
That
effect,
means
my lord.
shares are already transferred.
To us. So it has to, they have filed a civil suit.
When the shares were transferred, the date, on which date the transfer happened?
The transfer happened, one transfer has happened subsequently because of that the daughter was, she was Arjana. Arjana was not there. But to that effect, there is, but admittedly, my lord, my case is that to make out a case of 471, we must have the knowledge
That it is a forged document.
that it is a forged document and we must use it, my lord. But here,
And your case is as it was transferred during the lifetime of the Adilur,
yes,
and it was Adilur who,
has placed it before the concerned authority under the form.
yes.
So he has used that particular document, if it is a forge also. So by virtue of that, this transfer share has been transferred. There is no dispute. But whether we had knowledge to that effect, regarding our knowledge, there is no avertment at all. Absolutely silent. So if somebody transferred shares to me, my lord, whether I can be made liable for illegal transfer of the share. Let us assume it that this document is forged. The prima facie has said that she has never signed those two forms. Her statement is that I have never signed these two forms, but I have admittedly, she has also admitted that she has signed some blank papers.
But whether she has denied that this signature Nilofer is not her signature.
Yes, ma'am. That
She has denied
yes. Her
That-
signature she has denied.
that it is not my
It is
signature.
not her signature.
Okay.
But to that, so that part
That is
we are-
yeah,
yes,
that is under dispute. That
Yes.
is before civil court.
yes. That is her case is that this is not my signature.
Okay.
So she is saying that this is a forged document. So by making the forged document, by forging her signature, maybe my lord, the share has been transferred.
Okay.
But my case is that if it is
Even if it is forged, it was forged by
the Adilur,
not by you.
not by at that time we are not the directors. Her Nilufar, the complainant itself was a director at that time. Adilur was the managing director, and one more director is the one Mr. Maulong. They are the three directors at that time. So there is no question of transferring their share to us. We can't transfer it as we are not directors at the time.
Okay.
Because the her shares, the part of the her shares has been transferred. It was her share.
No, only Nilofer could have transferred her shares.
Yes. It wasn't. So we can't transfer it. So this is the case, madam, basic case, madam. And she has rather said that, but that's a matter of dispute, my lord. That she has signed in a blank papers in the complaint petition. She has said that I have given some blank papers signing the document to Adilur to use it for the purpose of buying some land. But whether that document has been used or converted to that effect, everything is silent, my lord. There's no allegation also to that effect. But let us assume it that her signature has been forged, my lord. Prima facie, she has made that case that her signature has been forged. And illegally, by forging the signature, the transfer has been made, my lord. So that is their basic case, my lord. But their own document belies their own statement, my lord. Because one way she said, my lord, in the complaint petition that it was transferred subsequently, but in the initial deposition, it is the other way around.
Okay.
So it is rather a case of a perjury. Because and to that effect, my lord, we are relying some of the judgment, my lord. And the most important part here, it was a case of a company, my lord. Company has not been made a party, my lord. একেলগে দি- হয়। Point কেইটা কি আছে আমাৰ part টো? একেলগে কৈ দিম। The first judgment, we are relying on, my lord, but you can only take down the paragraph, my lord. I'll not read, my lord, because time is short. 2015 8 SCC, my lord, 293, paragraph 12, my lord. This is regarding 420,
Okay,
that the initial reception is required.
okay, next.
Then next one is also, my lord, same 2020 3 SCC 240, my lord. Here is paragraph, my lord, from 7.2 to 8.2, my lord.
Okay,
From paragraph 7.2 to 8.2, same, my lord. The initial reception in 420, my lord. Next, my lord, 2015 12 SCC, my lord. 781. Paragraph 11 and 13, my lord.
yes, this is regarding,
Regarding, my lord, that the company needs to be made a party when the company is involved in a dispute, my lord.
okay,
This is also a case of 420. The prerequisite, my lord, where the company has not been arraigned as a party to the complaint held, a criminal proceeding initiated against the managing director were not maintainable.
okay.
And the next one, my lord, 2009 10 SCC 184, my lord. It says, my lord, only the mention of the sections and the vague allegation will not do, my lord. The complaint petition has to be specific how the accuser involved in the alleged commission of the offense, my lord. The precise involvement, my lord. Only just quoting the sections or the vague allegation will not do. Here, my lord, there is no allegation against us. Simply against accused number 1, there is no allegation against accused number 2. How the share has been against accused number 1, that she has transferred it subsequently to death. But that, as Lordship has already we have pointed out. But the rest of there is no allegation that we are aware of the fact that these are the forged documents. And next one is also, my lord, the 2011 3 SCC 351, my lord, that the uncontroverted document reliance in 482 under the CRPC, my lord. How the court can, when the court can take the uncontroverted document. Here, the letters and the title suit and the transfers form, these are uncontroverted document, my lord. Rather, they have relied on. These are all their old document, my lord. So it can be decided. That is paragraph 25, my lord. And the next one, my lord, that is the Lordship's own judgment, my lord, in criminal petition 3/2020-22, my lord. Dealing with all these, my lord, points, my lord, which I have already, my lord, are good, my lord.
Okay, yes,
So this is the case, my lord. Only one point, my lord. Now they have filed the affidavit.
what,
Now, my lord, as per as my limited understanding of the
what they have
criminal-
stated in their affidavit?
now they have brought in one document, my lord, which is not part of the initial complaint. No avertment to that effect in the complaint petition also. Now, my limited understanding of the criminal proceeding is that the subsequently complainant cannot develop her case in the proceeding, ma'am.
What document they want to?
Only one document they're showing that এখানে না?
certified copy.
This is a
Some
annual report,
additional. Additional.
certified copy of the document obtained from the register of the companies, my lord. That is the page 175, my lord. Probably what they want to show, that is the balance sheet.
Okay, let them submit.
In
few-
page 176, lordship will find the
Yes,
details of the share in the second column, my lord. The details of the shares held by the shareholders holding more than 5% of the aggregate particulars in 31st March 2012, my lord,
yes.
and 31st March from 2011, my lord. Probably they want to show, my lord, that the Nilufar Rahman, that is the 8400, that is the share she was still holding till 31st March 2012.
Oh, as per this balance sheet.
Then Afroza Rahman, that is her shares, but the probably Nilufar's so it is the complainant's name is appeared Nilufar Rahman till, my lord, 31st March 2012, my lord. If that be so, my lord, as your lordship has got it right. If that be so, that till 2012, 31st March 2012, she was still holding those shares. That means, my lord, that these two documents which they have relied in the complaint petition, that this share has already been transferred prior to death. It does not go together.
Okay. One of the documents have to be false,
Yes.
wrong document.
If that is the correct
Both,
document,
both cannot be correct.
both cannot be, because they are in this document, they say till 31st March 2012, so still holding those shares. Whereas their own case is that whole share has been transferred by virtue of these share form, two forms, and accordingly they are asking us to return it back. Initially, their whole case is there. Their annexes, their letters, everything, their title should, their case is that by virtue of these two forged documents, her share has been transferred to us. They are relying in these two documents. But in contrary to their own document now, it says till 2012, after the death of the complainant also, though those two alleged forged document has been placed before the authority concerned, but share has not been transferred. So therefore, they are very.
But Adilur died
Adilur died on 13/11/2012.
November,
Yes,
and this document shows that Nilofer was having the said shares till
31st March
31st March.
2012.
Okay. Okay,
So my contention is that there's a doubt. Though they are saying that these two documents are the forged document, and by virtue of this document, the share got transferred from her to me, to the accused person, whereas it's not that be so. There may be some other document also, by virtue of which the share has been subsequently may have transferred. Because these documents,
no, let the counsel for respondent side make his submission.
No, my case is that
On-
now they cannot develop it further. So these documents, first of all, this has no consequences today. It's-
Because they have not used this
They have
document
these
in the
document not been used as a part of the complaint.
complaint.
Neither this document, there's no avertment regarding these the complaint that though this document, the share has subsequently changed, subsequently been transferred, to that effect, no avertment in the complaint petition. Nowhere. Rather, their case is that it was transferred to our name on that particular date itself. When the paragraph 9 and 10, Lordship kindly see.
No, in their affidavit, they have not made any statement why they are producing these documents.
Yes.
So unless they make their submissions.
Even then, my lord, my contention is that these documents otherwise also cannot be at this stage, can be taken into account because this is not a part of the original complaint, and neither there's a permissible that they can develop their case subsequent to when the proceeding is
Filing of
going on in the 482 application, my lord. That's the law as I can understand, my lord. Otherwise, everybody, tomorrow they will come up with a fresh allegation. In the 482 application, every day fresh allegation will come up in a way of a document or way of some affidavit. Tomorrow they will say, no, this is not done. Tomorrow it's that we have to stick to the complaint petition and the annexes, whatever they have relied on in the trial court and the initial deposition. Not anything else.
Okay.
Beyond that, there's no scope for developing the case in the later stage, that no. Otherwise, tomorrow they can again may say that, they had the connivance.
Okay, Mr. Bora, I have understood
Yes.
your submissions.
Yes, ma'am. How much, madam?
Let him, let me hear his counter.
Yes, madam.
Then only things should be clearer.
My lord is pleased to see. My lord is pleased to see page 171. That is cognizance order. I will keep it as brief as possible. This is the order dated 14th of October 2015 at page 171, forming a part of Annexure 14.
Yes.
Yes. So my lord, it says,
171.
yes, 14th October 2015, 171.
Yes.
Yes. So it says, on perusal of CR, I find sufficient ground for proceeding against the accused persons, namely Afroza Rahman and Azana Rahman, under 420, 468, 471 IPC. Accordingly, cognizance under 420, 468, 471 IPC is taken. So this is the order where cognizance has since been taken. My lord, before going into the complaint, I would seek the permission of the court to bring certain facts on record from the documents, how it has led to the filing of the complaint case. My lord is pleased to see at page 129, that is the first letter at page 129, forming a part of Annexure 8. This is, in my respectful submission, not an afterthought. It is a fact that had come to our knowledge, and immediately we had taken the corrective
What is
measures.
this 129?
This is the letter that we had that I had written. Nilufar has written to Afroza, the sister-in-law. This is dated 2nd of December 2014. My lord will have the date. The subject line is transfer of shares, if I may.
Yes.
Dear sir, it has come to my knowledge that shares I am holding in Rahman Property Limited has been transferred to Afroza Rahman and Azana Rahman without my consent. For your ready reference, I am giving you the details of shares transferred without my consent. So the transfer period is 2007 till December 2013. This is the transfer period. And the number of shares so transferred is at the right side of the column. This is 2,18,100. And then there is a separate tranche of 8,400. So these are the two set of transfers that I say is a byproduct of falsification of documents by forging my signatures on the share transfer certificate, which I will now come to. So this is the communication that I had addressed. And I say, as you are aware, this is a serious offense and you are given 15 days time to rectify the unauthorized transfer and falsification of my signature
No,
on share
have you-
transfer.
You have also filed a civil suit.
That is in relation to a partition amongst all of the siblings.
You-
That is not limited to these shares alone.
But these shares are also involved.
It's involved because the company's shareholding is involved. There are two other gardens which is currently, under my control. All of these things are since pending before the trial court by way of a title suit, and there's a counterclaim as well. So that per se is not limited to the share transfer, my lord. It is forming a part of the partition, most definitely, but not the subject matter alone. So if I may, so here I say, as you are aware, this is a serious offense and you are given 15 days time to rectify the unauthorized transfer and falsification of my signature on share transfer done by you and the company. Please note that I don't want to take any legal action without giving an opportunity to rectify the status of shareholding pattern to prior 2007 status. I hope you will take this opportunity to resolve this issue amicably. Rectified status of the same need to be provided to me within 15 days time in my following address, so and so. Then the next letter at page 130. This is the response that comes from Afroza Rahman.
Okay.
The next page, forming a part of Annexure 9.
Yes.
So here it says the date of letter is 16th December 2014. Dear Nilufar, I have received your letter dated 2nd December 14 and noted the contents. As per the letter, you have alleged me of falsification of your signatures in transferring the following shares. So the period is still shown as 2007 to December 2013. So there is no per se clarity on the date even today when a letter is forthcoming from Afroza Rahman.
No, that is your she's only referring to
So
your
I understand,
allegation.
but I'll come to the actual share transfer certificate as well. So now it says, I put forward my contention in this regard. All the above mentioned shares were transferred at the time when my husband, Adilur Rahman, was the MD of the company and looking after the company law matters also. However, Azana Rahman shares were intimated with the registrar of companies later as a signature was awaited. As per my discussion had with my late husband Adilur Rahman during his lifetime, the transfer of shares were made after paying necessary consideration for these shares to you and with your due consent by following due process of law. Therefore, I am no way involved in transferring the shares as has been alleged and hereby deny all the allegations made against me. After almost 2 years of death of my late husband, Adilur Rahman, who happens to be your elder brother in relation, you are putting such allegation on me, which has no legal base. So there is a concern regarding the delay in raising this issue, which according to the petitioner, there is a delay of 2 years. Then it says, after the death of my husband, my daughter and I were most in distress and we expected family support from my in-laws. However, to my utter despair, we get such baseless allegations instead of moral support from the family and thus have shattered my goodwill as well as my enthusiasm to work. So this is the response that was forthcoming against my initial letter dated 2nd December. Then I respond to this at page number 133. At page 133, this is Annexure 9. My lord has it?
Yes.
Dear Afroza, I hope this letter finds you in good health, so and so. I maintain, A, I have never been informed about any board meeting of Rahman Properties Limited. B, I have never attended any board meeting of Rahman Properties Limited. Number C, I have not signed any share transfer forms and have not transferred my shares to anyone. D, my shares in Rahman Properties Limited have been transferred illegally by falsifying my signature. You have mentioned in your letter to me that the shares were transferred during my late brother, Adilur Rahman's tenure as MD of the company. It may be so, but still does not make the share transfer legal. So here I'm still giving the benefit of doubt. I have not signed any share transfer forms during
What
this
is the
tenure.
date of this letter, second letter?
This date is, I'll just This is 25th of July, 2015.
25/9/7.
25th July, 25/7, 2015. There is in fact, a reasoning why there might have been a delay in the first line itself, my lord. This reply was long due and the delay is due to my kids' exams and other issues. So there is a reason why there might have been a delay of 6 odd months in responding to this issue. Then, my lord, I still maintain at D, fourth line at D, I have not signed any share transfer forms during his tenure either. It is your responsibility now to sort out the issues since the shares have been transferred in you and Azana's name. So the beneficiary is most definitely the petitioners herein. That is Azana Rahman and Afroza Rahman. If you continue to hold the shares in spite of knowing that they have been transferred illegally, that you will be held responsible. As for the question raised by you in your letter as to rely, I have taken more than 2 years to put these allegations against you. My answer is that only after you filed a succession certificate and after receiving a notice date so-and-so, I inquired about my shares in Rahman Properties Limited, and to my utter horror, I found out that all my shares were transferred in you and Azana's name without my even signing a share transfer form. And that is when I wrote to you and the others. So my stance has been consistent all through. That I have not signed, put my signature affixed upon any of the share transfer certificate. So now if I may be permitted to go to the alleged share transfer certificate at page number 17. That is the first tranche. My lord, I'll just quickly highlight the dates. We might be constrained because of time. This is share transfer form at page 17. So it says number in figures, that is the shareholding concerned. It's 2,18,100 at 10 rupee value. And the dates in between, not the last date of approval, the date in the column it says 5th day of January 2012.
Yes.
So this most definitely is suggesting that this document was executed during the lifetime of my brother, late Shri Adilur Rahman. It suggests so because the date is definitely before his demise. His demise is in November. This is January, 5th of January.
Yes.
But this is my consistent stance that I have not signed any share transfer certificate, meaning thereby that this is a byproduct of forgery.
Okay, that is your allegation.
This is my allegation.
Okay.
Now, the second document at page 21, which is of relevance. And by virtue of me moving an application
But
today,
forgery has to be committed before 18/1, before it is presented to the ROC registrars.
I'll come to that. That is the only reason I had brought these ROC documents. These are statutory compliances. I'm not bringing anything to the contrary. These are statutory documents that I will rely upon. At page 21, it says,
No, my query is different.
please.
My query is from your submissions as well as documents which you have relied. It appears that forgery was, even if it was committed before 18/1/2012, before the date on which the share transfer forms were presented to the ROC.
18/1/2012.
12,
This is the stamping date.
stamping date.
But I cannot today authenticate any of these things because according to me, this is a byproduct of forgery. What I can rely upon is the annual shareholding.
No, but you are saying that shares are actually transferred in pursuant to these documents. Forgery is only in relation to your signatures. That
Yes.
is the allegation. The seals are not forged signatures.
So that's right. That's correct. But I'm not even.
Your case is that in pursuant to these transfer forms, shares are actually transferred to Afroza and her daughter.
I will rely on the annual return that I'm now
No,
placing.
why I'm putting queries?
I will just come to that.
I am
Your
concerned
lordship will
with the
just bear with
date
me.
on which the
I'll come to that. That precise question I'll respond. My lord will
Yes.
just bear with me. So this particular document at page 21, I just want to quickly highlight the date in the column. Here the approval date is missing at
Page-
page 21. The date still suggests 5th January 2012, which is the same date
Yes,
that the other document was so executed.
both the documents.
Both the documents executed on 5th of January, stamping is of 18th of January 2012.
Yes,
This is the situation. Now coming to the complaint. The complaint, which is at page number 140. I will just read few of the paragraphs.
Today
Yes,
we have to wind up at exactly at 4:30.
Please, madam.
We have a full court meeting.
yes, I'll
So-
endeavor. I'll endeavor to close. At page 141, my lord, this is
Yes,
the complaint petition at page 141. This is forming a part of Annexure 12.
yes,
At para 4, very quickly, that this is my case. That there were number of directors in Rahman Properties Limited, and they were Adilur Rahman, that is my brother, the husband of accused number 1, the complainant, that is me, Nilufar Rahman, Sajid Haq Maulong, that is the other gentleman, and accused number 1. And each of the directors had shares in Rahman Properties. So the accused number 1 was very much a part of the directorship. And that I say was in directorship since year 2004.
okay,
This, I will seek the liberty to highlight one page which is forming a part of my ROC records. My lord, these are ROC records. This is certified copy of ROC documents only to buttress certain facts which is not presented in correct light. At page 215. The part of the additional affidavit, 215. At page 215, my lord has it. This is forming a part of the annual return of shareholding. 215. So this starts at 213, just to give some perspective. My lord may see page 213, just to gain some
Yes,
clarity.
213.
213 is the annual return for the year 2012-2013. Now, this is statutory compliance.
yes.
If
What do you
if
want
my-
to show?
Yes, if my lord is pleased to see the date of AGM, I'll just quickly mark. Date of AGM, my lord has it. 28/9/2012
At page?
at page 213. The first page
Yes,
where the document is in
Yes.
starting. Date of AGM, 28th September 2012, during the lifetime of late Shri Adilur Rahman. My lord will just quickly take a note of these things. This AGM happened when my brother was alive.
yes,
Yes, now at page 215. Now we are looking at the directorship of Afroza Rahman. That is the petitioner number 1. At page 215, the third column, Afroza Rahman, my lord has it.
yes,
It says date of birth so and so, date of appointment 8th of October 2004.
okay.
Since 2004, the petitioner 1 was acting as a director, having shareholding in the company.
So what do you want to say?
I want to just come to the next point, that she was very much a part of the company who could have been a part of the conspiracy, connivance or whatever, leading to the illicit transfer of the shareholding. Contrary to
No,
these submissions.
but in your initial deposition before the magistrate court, you have accused only Adilur specifically.
Well, that might not be correct, because the entire coming to light of this issue happened in 2014. And then when we did our due diligence, it has come to light that the second tranche happened after the demise, which I will
No, no,
prove.
what I'm on, in your complaint, you have alleged in para 9 and 10.
Yes, I'll come to that.
In para 9 and 10, you have made allegations against the present petitioners.
Correct.
But while deposing as witness under section 200
Yes.
CRPC, you have not stated anything against the petitioners. You have stated that it was the Adilur who, that is the submission of the council. I have not verified, but if it is so,
My lord, I'll just read it out. Let me read it out.
no,
Let me
no,
read it out.
I am not disbelieving you.
Read it.
I am,
My lord, my colleague will just
no,
read this
on,
portion.
My lord, the oath, my lord, initial deposition of Nilufar Rahman, my lord, it is a part of the records. my
yes. No, on that you have some answers.
Yes, my lord, it says so.
May I read, my lord?
With the permission of the court, my
Yes.
colleague will just read out.
Yes, yes.
Initial deposition, my lord, to kindly have of Nilufar Rahman.
At page,
My lord, it is a part of the
Reading.
oh, yes, in the LCR.
LCM.
Yes, read it. Yes, please.
The deposition of PW1. My name is Nilufar Rahman. On oath. মই
I can read
মই
it better than.
মই আসামীজনক চিনি পাওঁ। আফৰোজা ৰহমান মোৰ বৌ হয় আৰু আজানা মোৰ
Please, please.
আফৰোজা ৰহমান মোৰ বৌ হয় আৰু আৰানা মোৰ নাতিনী হয়, ভতিজী হয়। ৰহমান প্ৰপাৰ্টিজৰ 2,26,500 শ্বেয়াৰ মোৰ নামত আছিল। মোৰ ব্ৰাদাৰ আদিলুৰ ৰহমান যোৱা 30/11/12 ডেথ হয় আৰু কেইদিনমান পিছত মোৰ বৌ আফৰোজাই ছাকচেছন বিচৰা বুলি নটিচ আহে। আমি তেতিয়া শ্বেয়াৰ ষ্টেটাছৰ উলিওৱাত গম পাওঁ যে মোৰ নামত থকা No, this is evidence. You are reading the, I'm sorry, Lordship, she is reading the evidence of the PW1, my lord, informant. My lord, initial deposition marriage note. Or not, A. Gusor, Afroza Rahman, sister-in-law, niece Arana Rahman, Sajidul Khan, director of Dynasty Hotel. More Hotel Dynasty director asilo, Aro Murnamo, 2,26,500 share asil. Mur dada late Atiku Rahman, Rahmane Hotel or আদিলুৰ ৰহমানে হোটেলৰ এফেয়াৰ চাইছিল। মই বিশ্বাসত সকলো দায়িত্ব তেওঁক দি দিছিলোঁ। যোৱা 13/11/2012 মোৰ দাদা ঢুকাই মোৰ চিষ্টাৰ ইনলৈ যেতিয়া ছাকচেছন চাৰ্টিফিকেট এপ্লাই কৰিলে তেতিয়া ময়ো হোটেলৰ শ্বেয়াৰ এটচেট্ৰা কথা জানিবলৈ ৰেজিষ্টাৰ অফ কোম্পানীজৰ ষ্টেটমেণ্ট ল'লোঁ। কিন্তু গম পালোঁ যে মোৰ নামত থকা 2,18,400 শ্বেয়াৰ মোৰ দাদা ঢুকোৱাৰ আগতে মোৰ চিষ্টাৰ ইনল আফৰোজা ৰহমানৰ নামত ট্ৰেন্সফাৰ হৈ যায়। বেলেঞ্চ 8,400 শ্বেয়াৰ মোৰ দাদা ঢুকোৱাৰ উইদিন 3 উইকছৰ ভিতৰত মোৰ নিচৰ নামত ট্ৰেন্সফাৰ হৈ যায়। তেতিয়া ডিচেম্বৰ 2014 মই মোৰ চিষ্টাৰ ইনলক এই বিষয়ে জনাই এখন চিঠি দিওঁ আৰু ছেটেলমেণ্টৰ আগ্ৰহী বুলি জনালোঁ। চিষ্টাৰ ইনলৈ শ্বেয়াৰ ট্ৰেন্সফাৰ কৰাৰ কথা একচেপ্ট কৰি ক'লে যে এইবোৰ লৈ যাতে তেওঁক ডিষ্টাৰ্ব নকৰোঁ। ইন দ্য মিন টাইম আকৌ ছেকেণ্ড লেটাৰ দিওঁ কিন্তু বেচলেছ এলিগেশ্যন বুলি কথাটো ইগন'ৰ কৰিলে। মোৰ কনচেণ্ট নোলোৱাকৈ শ্বেয়াৰ ট্ৰেন্সফাৰ কৰিছে, কোনো পেপাৰে চাইন কৰা নাই। মই মোৰ দাদাক কেইখনমান ব্লেংক পেপাৰ চাইন কৰি দিছিলোঁ কাৰণ তেওঁ লোন আৰু হোটেল ৰিন'ভেট কৰাৰ কাৰণে সেইটো লাগে বুলি কয়। মই বিশ্বাসত চহী কৰি দিওঁ।
Okay. So it is mentioned that before death,
Yes.
8,400 shares were transferred.
Before death, 2
and
lakh,
After death,
2,18,000 before death. 2,18,000.
2,18,000 and 8,300
8,400 was done prior,
after
post the
3
demise.
weeks of his death.
Yes.
Okay,
I'm continuing with that document, which is,
okay.
according to me, is of relevance, my lord.
Okay.
I leave it upon your lordship at page 216.
Yes, 216.
Just one document very quickly.
That
This
the
is-
Afroza is the director.
Is the director since
2004.
2004. So that submission might not be,
Tomorrow,
my lord may have it tomorrow. If it,
tomorrow Can we continue
Yes.
tomorrow, day after tomorrow?
I am here, my
Tomorrow. Heard Mr. A. M. Bora, London, Senior Counsel for the petition, assisted by Mr. F. Assisted by Mr. A. Borua. Also heard Mr.
And thus,
N. Das, Learned Counsel for the this
R2, R1. Complaint.
respondent number 1, as well as Mr. R.J. Soikya, Learned, R.J. Borua, Learned Counsel for Learned Additional. Can we have it on Monday? Or it will be difficult?
My lord,
You will be leaving.
I'll be leaving.
So we'll,
Any date after 20th till 30th, I'm in Guwahati.
because
so-
tomorrow I have it. DB.
I have no problem, my lord. Because he is coming
The-
from outside.
The argument, the argument remain inconclusive. When do you want it?
My lord, may I have it on
I
20th,
don't want to delay it because
20th?
20th, on
20th
20th.
June.
Because he has to only reply you,
Okay,
and then you may have to give some
clarification, I don't have. Yes.
let this case be listed again on 20 June as part admitted.
Published.